morning, everybody. Welcome on this lovely sunny morning to our webinar on taking charge, how to protect your future with wills and powers of attorney. Our guest speaker today is Emma Gray. Emma was a private client solicitor specialising in legal papers for end of life, but she paused her legal career after sadly becoming a young widow in her 30s. When she was in practice, Emma's work included wills, probate, tax, trusts, powers of attorney, and other vulnerable adult matters. Emma has been a member of the Association of Lifetime Lawyers, previously known as the Solicitors for the Elderly and the Society of Trust and Estate Practitioners, for many years. Emma is now a grief and life coach. She's also an ambassador for two charities, Way, Widowed and Young, and Milspo Network CIC, an organisation for military spouses, partners and other halves who run their own business. She's also a trustee for the Royal Marines RMA charity, and she's a dementia friend. Until earlier this month, she was a national board director and head of regions for Lifetime Lawyers and on the advisory panel for Society of Later Life Advisors. More recently, Emma has set up her own initiative, Rainbow Hunting Limited, to help those who've been touched by grief to sort their practical and emotional legacy through supportive workshops, courses, and one-to-one coaching sessions. As well as being a coach, Emma is retraining as a counsellor. She is a bereavement support volunteer for Cruse, and her dream is publishing her first book. Through her coaching and courses, Emma supports her clients with practical and emotional things that need to be done to prepare for death and dying. Having experienced the heartbreak of her loss herself, Emma is passionate that if we all sort these aspects out, then it frees up space to chase rainbows and find joy in life. I'm now going to hand over to Emma. Emma is going to talk to us for about 40 minutes. Following this, there'll be an opportunity to ask questions. Please feel free to put them in the chat box below. I think we've had a few questions that have come in, prior to today, so we'll put those in. So we're hoping for 10 or 15 minutes at the end of the presentation to have a look at some questions. Today's session has been recorded so that we can send it out to you, and if anybody misses anything, they can listen into it. That's all from me for now. So I'm going to pass over to Emma to do her presentation, and I'll host questions again at the end. Thank you.
Oh, thanks, Jane. So I haven't called this wills and powers of attorney. I've called it a widow's view of Sadmin because although my background is legal, I'm going to try and talk to you from a very practical perspective. So to get us started, what I'm going to say over the next 40 minutes, this is for you if you're not sure about wills and powers of attorney. You've got some niggles, some questions that you want me to help answer. If you're not sure about, I think a lot of people can't quite see the benefit. They can see the headache, but they can't quite see the benefit of doing this paperwork. Maybe you don't know where to get started. Maybe you're not sure what the benefit is for other people and where and how to get started. What I'm going to run through with you, I love this little picture of the muddy boots, partly because I tell my kids that a happy kid is a mucky kid, because it's my way of coping with not enjoying the mess, but partly because I think people often get stuck when it comes to wills and powers of attorney. There's often lots of questions, and sometimes people don't even know where to go for the answers. So I'm hoping I can help answer it today. But I'm going to start off by telling you a bit about my journey. Jane's given you a bit of background. Apologies to Jane for giving her so many acronyms and all the rest of it to get her tongue round. But I'll explain a little bit about why I really am quite so passionate about this. I've called this end-of-life paperwork SADMIN, so I'll explain to you what I mean about that. And then one of the things I thought I'd go through is the challenges and what I call the mind monkeys, the things that can stop people, because sometimes you don't realise what it is that's stopping you from doing this, and hearing other people's stories can shed a bit of light on that. I've got a few real life stories, obviously no names, but real life stories about consequences of procrastinating. They're picked from when I was in practice, and they're actual cases that came across my desk. Then I'll end with a bit of practical advice about how to do it. So there's quite a lot to cover in 40 minutes. if you're watching this on the recording, you can press pause, you can rewind and go back or speed up, although I'm not sure anyone wants to speed me up because I think it might just be horrendously difficult to understand me. But because I've got quite so much, as Jane said, if you don't mind, please, please, please put your questions in the chat box, and Jane's very kindly going to host a Q&A for the last kind of 10, maybe 15 minutes, depending on how long I talk about. So without further ado, a little bit about me, from the professional there with a lovely certificate that I got when I was in practice, to the crazy, which is I love cold water swimming. I was listening this morning about how good going in the cold water is for us on a podcast. But as Jane said, I'm a grief and life coach. So what that means is I help people find the answers inside themselves when they get a bit stuck, either with their emotions around grief or general life admin. And because of my background as a former wills and probate lawyer for many years, I specifically specialise in helping people sort out the end of work paperwork, but I'm no longer a lawyer, so I don't draft it anymore, and I don't give legal advice, but I help with all the mind monkeys, because I realised in practice that actually the mind monkeys are almost more tricky to get your head around than the legal paperwork sometimes. As Jane said, I'll go through it in a tiny bit more detail, but I've been a widow since 2016, when my husband very sadly died of esophageal cancer at the age of only 38. He was a Royal Marine, he was Lieutenant Colonel when he died, so in his 30s he was quite punchy at work. The wife worked and paid for the extras, but he was really the priority in our world. But since he died, I've been diagnosed as having ADHD, which actually is a whole separate presentation on its own. But I mention it just to say that if I can get my head round all the paperwork and all the difficult bits and bobs with a crazy brain, then I like to think that I've got some pretty good coping strategies to help other people. I've done 8 years now of solo parenting, 2 girls who are now teenagers. They were 3 and 5 when my husband was sadly diagnosed. They were 6 and 8 when he died in July 2016. And they're now shockingly 14 and 16. And I can't quite believe how quickly time is flying. My husband always wanted the children to have ponies. It was one of his dreams, and it is another reason why I'm really passionate about this, because he's given me the financial freedom. We never owned horses when he was alive, but since he died, I seem to have accumulated a herd of 3, and one of whom is less than 2 years old. The horses have been the best thing I've ever done. But if I hadn't been organised when Simon died, and if I hadn't had the financial freedom and all the organisation we'd done with wills and powers of attorney, then that dream would never have come true. And then my favourite animal is our little Mulshi-Poo dog, who is the size of a cat, called Lola. So that's a little bit about me. My husband, obviously being in the military, I did a lot of what I called semi-solo parenting. So I was kind of used to the solo parenting because he was away so much, Afghanistan and Middle East and all that kind of stuff. But after he was diagnosed, we had 2.5 years of bucket list days. So that was things like taking the kids on their first skiing holiday, going to Euro Disney, doing things like that. And I really do believe that the more you can organise the paperwork, sort the paperwork out, I'm kind of the guinea pig. I'm the living, breathing evidence of the fact that it is possible to find these rainbows and to find the joy. And actually my rainbow hunting philosophy kind of started in 2014. So when he was still alive, that, you know, the world can be a really difficult place sometimes. It can be cold and it can be wet and miserable, but actually you've got to keep faith, because the sun and the stars are always there, so you can go find your rainbows. So his death on the 11th of July 2016, it wasn't a surprise. He'd slowly got more and more poorly, but it was an epic shock. And I do a lot of advocating about grief, a lot of training about grief for corporates and individuals, because I believe that, you know, we can think we're prepared and we can think we're organised, and with the paperwork we can be, but the emotions can be the real shock. Not just the fact that they're not here anymore, but how we react And I thought, being a wills and probate lawyer, I'd be like on it, and I'd sort out the paperwork, and I'd be hugely organized. And actually, I was physically heartbroken. Like, my heart actually hurt. It felt broken. And that really surprised me and really gave me quite a shock. We had a year of firsts. Anyone who's been through grief, that year of firsts, there's quite often a lot of people who are around to help out. And then life started to get a bit hard, but I made some big changes, moved closer to school to make life easier. And although my work was going very, very well, so that picture of me getting commendation for doing really well at work was actually taken only a few years after my husband died, but home was becoming a massive struggle, massive struggle. So when rainbow hunting started, it was kind of as a consequence of doctors' orders to slow down. So I paused law. Ironically, I paused law to spend more time with my children and to settle into this new house that we had. But we, 3 weeks after I'd finished working my notice period, because I was worried that I wouldn't go back, so I wanted all my clients handed over properly, we went into lockdown, and I was like, heapers jeepers. I wanted to spend more time with my children, but I'm not sure I wanted to be with them 24/7. And I'm definitely not a teacher. I can advocate and educate about grief, but I am not good on prep school maths and English and all the rest of it. Google is much better than me. But I discovered writing, and some of what I do with rainbow hunting is sharing my story, both as my own therapy, that every time I write, it helps me process it, but also to normalize grief, to normalize the importance of getting all this paperwork sorted. Part of the acceptance in my grief, I was the widow. That's a picture of me at the cenotaph for the Royal British Legion on their centenary anniversary to celebrate 100 years of the Royal British Legion. As Jane said, I'm a widow who is an ambassador for a charity called Way, Widowed and Young. My children discovered the most amazing charity called Scotty's Little Soldiers. And they help bereaved forces kids and do things like respite breaks and therapy and things like that for bereaved forces kids. I am a bereavement support volunteer, as Jane mentioned, for Cruse, which brings me a lot of comfort knowing that I can use my experience to help other people. The New World with Jerry, Arthur and Lola actually should probably have a little bit more, because those are all our pets. So Jerry's one horse, Arthur was a pony who we had on loan for a little bit. We now have Smarty and Wanda as horses, and Lola is obviously the dog. And rainbow hunting's kind of been about finding my soul's purpose. Bizarrely, the discovery of ADHD was one of the best things that's happened to me in widowhood. It enabled me to really accept every single part of me and truly embrace the little things. So I feel like I'm the evidence of why sorting the admin is so important. Here is Lola, she's in the top picture. And then we've got Smarty and Jerry, then me and my girls when they were much, much younger. And again, that was at a festival after Simon had died. And this is at Buckingham Palace. And this, I think, illustrates the roller coaster in grief. So you can have amazing things. This was a Buckingham Palace garden party for bereaved forces kids that we were fortunate to be invited to. But sorting this admin has definitely brought me some certainty in an uncertain world. One of the reasons that I share this like part of my journey with you is grief turns your world upside down. But if the paperwork is sorted, it really does provide certainty in a world that suddenly seems quite frightening and uncertain. It's very normal for people who are bereaved to have quite high anxiety, but if all the paperwork is beautifully in order, it makes life a lot easier. I've already illustrated the financial freedom, and I think it's also given me time with loved ones. So being able to hit pause on law has enabled me to spend more time with my children. And it's part of the whole other topic of grief, but I really believe in something called continuing bonds. When someone has died, you have a new relationship with them. You don't want them to disappear from your world because they mean a huge amount to you, and they always will do, but they're no longer physically with you. So it's about the continuing bonds with that you have with that person who's died. and to be able to have advice and support from the grave because you've done the paperwork and you've sorted the paperwork out is priceless, really. And some of the letters and hard work that my husband put into organising his legacy has been the most amazing emotional handrail in some very rocky times over the last 8 years. So on to the practical stuff. What is this word sadmin that Emma has dreamed up? In my head, it's all the end of life admin that's emotional and sad. And there's 2 types of it. So I've labelled them into post-death and pre-death. So the stuff that's post-death, that's after the loved one dies. And sadly, this is my late husband's funeral here, his coffin with the military flag and what have you on it. And after the person dies, you've obviously got the probate to do, you've got to transfer assets into the beneficiaries' names, you've got personal possessions to sort out. One of the things that people don't talk about enough, I don't think, is digital legacies. And then GLAG is my word for growing life around grief. And having the paperwork sorted means that people have the emotional capacity and brain space to be able to focus on processing those emotions. But I'm not going to talk to you about the post-death. That's not what today's about. Today's mainly about wills and powers of attorney. So that's the pre-death. And this is my lovely husband only in the February before he was diagnosed. And actually he would have had cancer at this stage with our 2 kids. But pre-death is about sorting your affairs. And that's what we're here today to talk about. Can't take away the pain of the grief. But as I've said, what we're going to talk about today is about providing that emotional handrail and the practical paperwork for your loved ones when you're no longer here or not able to do things. So why it helps the individual. This is my lovely husband loved cycling, and this is him doing his favourite thing, which is eating on a break when he cycled the entire route of the Tour de France in the same time frame as the professionals, because he's a Royal Marine and he did stuff like that. But what it brought him, and he put a lot of effort, with my help, admittedly, but into planning his end-of-life paperwork. And what it really brought him in the headline is the peace of mind. But he also was really passionate that he wanted to leave a legacy and he didn't want to be forgotten. I think he was also, being a Marine, he very much wanted to stay in control. He wanted to have control of the care. He knew he had cancer. He knew what type of cancer he wanted, and he wanted to stay in control of the potential treatment that he would need in the future and what would happen towards the end of his life. It also gave him a massive sense of purpose. It gave him something to really stick his teeth into. So he put a lot of effort. He did video blogs and all sorts that I will talk about a little bit at the end. I think it also makes people more organised day to day. So when you move house, when you go on holiday, everything's a lot less stressful if you've got a beautiful Excel spreadsheet, which says everything that needs to change dress and so on and so forth, or passport. You don't want to do what I did the other day, which is go to Wales to get a same day passport for my daughter who's going to Malta on Friday. So even me can get things wrong still, but I think that generally having your sadmin sorted really does ease up the stress that can otherwise come into our world. And also, when you're thinking about end-of-life care planning, if you've written down your wishes, actually statistically it reduces the potential for inappropriate care and admissions at end of life. And I think the last thing people want when they're really, really poorly is to be taken to hospital when they don't want to be taken to hospital or need to be taken to hospital. So it's also about dignity and comfort at the end of life. And I do believe that it is possible to have the best death possible. I know that death, I'll talk about an elephant in the room in a bit, but I know that death is not talked about much, but I do genuinely believe that it is possible to have the best death possible. So for everybody else, what does it do for all of those of us around the patient and person themselves? Again, it's about peace of mind. This is my 2 gorgeous girls, just evidence that they don't always. There's a lovely picture of them looking into the sunset, but it was quickly followed by them trying to get each other in the water. But it gives everyone else improved communication. There's less trauma at the end of life. And, you know, we think of trauma as a massive car crash or something like that, but actually the little t trauma can be really upsetting and activating as well. It gives us all less stress, less guilt, less worries. Some of the decisions you have to make at end of life can be really, really difficult if you don't know the person's wishes. As I said, this emotional handrail is something that I'm really, really keen on. And also ease of administration, being able to find all the bank accounts, being able to find all the investments, and providing that priceless legacy and those continuing bonds. So on to what I call SADMIN. I've broken it down into kind of 5 parts. I'm going to go through each in detail, and you know, looking at them all together, it may seem overwhelming, but it is possible, broken down, for people to sort all aspects out if they really want to. I'm going to focus more on the wills and powers of attorney bit, but I do help people with all 5 aspects. So as I said, I'm going to focus more on the legal stuff. And the things that you were advertised today for were primarily will and power of attorney. So what comes under the legal SADMIN is the wills, understanding inheritance tax, maybe trusts, whether they be trusts of your home, trusts for blended families, trusts because you've got disabled beneficiaries, whatever those trusts might be. And what a trust is, and apologies if I teach people to suck eggs on this, but a trust is when in your will you give a gift to trustees, and the trustees hold that money as the legal owners on behalf of beneficiaries, and they're the kind of caretaker, if you like, of that trust pot. And then you leave directions for them as to the purpose of the trust and how the trust is going to be managed and how long it's going to go on for, and so on and so forth. Then there's powers of attorney, advanced decisions, and deputyship applications. I'm not going to talk about deputyship applications other than to say that a deputyship is what people have to get if there is no power of attorney and someone loses capacity. And if anyone wants to know a bit more about that, please let me know, put a question in the chat box and we can talk about it afterwards. But the deputyship application process, because the person has lost capacity and has not written powers of attorney, you have to apply to the court. And to get a deputyship is a lot more costly and a lot more time intensive. So for a lot of reasons, it is very important to make sure you've got a power of attorney in place so you don't need to do a deputyship application. So wills and powers of attorney, just differentiating between them. And again, apologies if I'm oversimplifying this, but your will is the only legal document saying who gets what when you die. So your will comes into effect the day you die, and it specifies who the beneficiaries are, who will inherit your estate. So the people who are in charge of taking a snapshot photograph of your estate the day you die, those people are generally called executors. Sometimes they're called administrators. There is a slight legal distinction between the two. Executors generally is the name if you've done a will. Administrators is generally the name if you've not done a will. But whoever it is, executors or administrators, their role is to take that snapshot on the day you die and work out all your assets, all your debts, pay any inheritance tax, sort out the funeral, then distribute the estate as per your will. Now, if there's a trust and it doesn't specify otherwise, the executors usually become automatically the trustees as well. As I said, the trustees are the people who are the caretakers of the trust money for the beneficiaries. And the beneficiaries are the lucky people who inherit whatever it is that has been gifted in the will, whether it be money, property, whatever it is. Now, the difference with powers of attorney is powers of attorney are for your lifetime. So it's the legal document specifying who can make decisions if you lack capacity in your lifetime. So what you're doing in the power of attorney document is you are delegating decision-making powers to the attorneys. So you're writing in the document that those are the individuals you are going to trust, that God forbid you can't make your own decisions at some point in the future. These attorneys step up and they start making decisions on your behalf. And so I mean, both the executors and the attorneys are really, really, really important people. They need to know what your assets are. They need to know what your wishes are. And you're asking them to do a very, very difficult job if you haven't got your paperwork all sorted and if they don't know your wishes. So just on a few will basics, if you don't have a will, what happens is that your estate passes in accordance with what's called the laws of intestacy. And there is an entitlement. So the first who normally has a call on the estate is normally a spouse. If there's no spouse, the next one is the children. If there is no spouse and no children, then it really interestingly, the next person with a call on the estate is parents. And this is why actually for a younger generation, it's really important for them to do wills, because often they want to leave their estate to brothers and sisters, but siblings only inherit if there's no spouse, no children, and no parents. So what actually can happen is if someone my age has no will, and they die with no spouse or civil partner, no children, their estate passes to the parents. But if the parents are already over the inheritance tax threshold, that may not be what people really want. So one of the things I'm really, really passionate about is that younger generations think about wills as well, not just because of how it impacts on them, but how it impacts on the people who might inherit from them in the future. And the other thing that people don't always realise with the laws of intestacy, and the only reason I'm talking about the laws of intestacy is just to stress how important it is to have a will, because if you have a will, the laws of intestacy are irrelevant really, as long as the will's not contested. And your will is the document that says that's what's going to happen on your death. But if you have no will, then actually there are financial limits. So if there is a spouse and children, the spouse does not get the entire estate, and that's often not understood. So it's really important for people to have a will so that your estate passes to the people you want on your death. The next thing I wanted to just kind of myth bust, if you like, is that people often think that there's such a thing as a common law spouse for wills. So if you die with no will, they go, oh, it doesn't matter, we live together, so they're going to inherit. It's like, no, if you are a cohabitee or an unmarried couple, under the laws of intestacy, and remember this is if you've got no will, there is no automatic right. So it really is important for people cohabiting. And if you are yourselves, or if you have younger generations who are partners up and they've bought a house together, it's really important for them to have a will to say whether the survivor of those cohabitees is going to have a right to keep the house or to live in the house. And also unmarried same-sex couples have no rights under the laws of intestacy. So those initial couple of bullet points are really just there to stress the importance of having a will and getting it done properly. The one really interesting thing about wills is it's really important for them to be executed correctly. And by that, it's a legal document. It has to be signed in front of 2 witnesses. Those witnesses must be adults and they cannot benefit from the will. So you can't have someone who's beneficiary in the will. So the best thing to do is to go to a solicitor, because the solicitor and their secretary are usually the 2 witnesses, and you can be absolutely certain that your will be done correctly. Then one of the last basic points I wanted to just highlight about wills is the difference between marriage and divorce when you do have a will. So if you get married and your will doesn't say anything else, then your will is entirely revoked. And I think that the reason for this coming into effect is because when you get married, a new person comes into your world, so they potentially weren't even in existence before. So it kind of makes sense that it goes in accordance with the laws of intestacy and the spouse is the first with a call on the estate. But if people get married, it's really, really important to make a new will. And you can make a will in contemplation of a marriage to a certain person. So you could do a new will just before you get married, saying, you know, I make this will in contemplation of my marriage to Emma Gray. I'm not planning on getting married, but just as an example, and the will won't be voided by that. In contrast, divorce, the will document is still valid if you get divorced. But what happens, it's as if you got really, really angry and you've gone through the document and the ex's name is scratched out. So it may be that you need a new will anyway, because it may not function very well without that person in it, because the chances are they're probably a key player. So basically, marriage and divorce are really important triggers for people to get a new will. A couple of mistakes. So some people have out-of-date wills. Some people annotate their wills. If you want to make a change to your will, it has to be done legally. It has to be signed in front of 2 witnesses. So it's either a new will or a codicil. You can't annotate a will. It's just not valid. Sometimes people forget to appoint guardians. So guardians are the people who look after minor children. So that's under the age of 18. And it's really important because actually the situations where you aren't sure about guardians are usually the situations where there potentially might be an argument. So it's guardians are a really important thing for young families to think about. It's really important to think about terminology. Now, all of these points I'm saying with the mistakes, every solicitor should know these. It's their bread and butter. But just so that people feel a little bit more knowledgeable when they go and see lawyers, one thing that's really important with terminology is the my children you need to be really careful. Adopted children are treated the same as biological children, but stepchildren are not. So if you have stepchildren, you need to specifically name them in the will or make sure that the lawyer knows that you've got stepchildren and they're going to inherit as you want. The other bit of terminology that's often very interesting is people either being too specific or too general. So if people want to give, say, for example, the gift of my blue Audi, if they then sell it and get a black Audi, the gift fails because it's no longer a blue Audi in their estate when they die. But also it could be too general. So I give my car, or if you've got 6 cars, how's anyone going to know which car it is that you want to gift? So it's really important to be careful with terminology, and also terminology when you instruct the lawyers so that they're doing the right things for you. Another mistake is foreign assets. We always used to have a blanket rule. If you've got assets in a foreign country, it's really important to go and get legal advice in that country where the assets are. You may need to have more than one will. So a UK will dealing with all your worldwide assets, for example, except for France, and then having a French will that just deals with the French assets. But you want to make sure that your lawyer knows that and that they don't mistakenly revoke each other, so that they work well together. And also to put copies, so a copy of the English will with the French will and a copy of the French will with the original English will. Property ownership is another really tricky point. Do you own your property as joint tenants, meaning that it automatically passes to a surviving joint owner? Or do you own it as tenants in common, meaning that you have a specific share and it passes in accordance with your will? And that's really, really important, because if you own it as joint tenants, it doesn't matter what you say in your will, the property passes to the surviving owner. People also sometimes, I used to find, forget that debts are paid first. So it's really important if you're giving gifts of money to make sure that you actually have sufficient funds in the estate to be able to pay that, because the debts get paid first, like the mortgage and so on. And one mistake I'm big about is having no will or DIY wills, because as you can tell just from these last couple of slides, this is easy for the lawyers, but it's not what you know that's going to trip you up. It's what you don't know. So really, really important to get a will done and get it done by a professional. Powers of attorney. So there was an old system called enduring powers of attorney. When I say old, this is pre-2007. The new system is lasting powers of attorney, LPAs. There are two types. One deals with your health and welfare, and one deals with your property and financial affairs. And it kind of does what it says on the tin. So health and welfare is all about where you live, the treatment you're going to have, and so on and so forth. The property and financial affairs is about your property, your investments, your bank accounts, speaking to BT on the telephone, those sorts of things. It is possible to have a separate lasting power of attorney, LPA, for business if people have different people that they want to be able to act on their behalf if they're still alive, but for whatever reason unable to manage their own business. And it's really important, if you don't do a separate LPA, to realise that the LPAs, the property and financial affairs LPA that you have, to realise that those attorneys will be able to manage all your affairs, and are they the right people? And I mentioned deputyship. So attorney is the name of the people who are appointed under these LPAs, lasting powers of attorney. If someone gets to a stage where they've lost capacity and they have no power of attorney, or for whatever reason their power of attorney is not valid, you can still act on someone's behalf, but only if you apply to the Court of Protection for what's called a deputyship. And as I said, it costs a lot more. And when I say a lot more, I'm meaning thousands plural. And it's so much more time consuming as well. And there's a lot more hoops to jump through. And you have to have a capacity assessment form done by a doctor. And I used to do a few deputyships, and it's really worthwhile when it happens and it comes through, because the difference it makes to people's lives in a very difficult situation is magic. But basically, please avoid the deputyships by doing your powers of attorney now. An advanced decision kind of crosses over with the health. I put it in the legal because it's a legal document, but with the health, you've obviously got the health and welfare lasting power of attorney. That's where you delegate the decision making to the attorney. An advanced decision is a legal document, but it's when you know the treatment you're going to have in the future, and you have specific requests for what you don't want. You can't say treatment you do want, that's euthanasia, but you can refuse treatment. You can say that you don't want to be resuscitated. You can say that, and you know, what's fascinating is what is life-sustaining will depend on your condition. So antibiotics could be life-sustaining treatment, but the advanced decision is the document, the legal document, where someone says the treatment they don't want to have if their diagnosis progresses. Advanced statements is just really a letter of wishes, adding a little bit more detail on that health and welfare care that goes with the advanced decision legal document. So it's a little bit like doing a will and then doing a letter of wishes explaining what you've put in your will. Advanced care plans are often done with doctors. So my late husband kind of bundled advanced care plan and advanced decision and advanced statement all together in one go, really. And it was the hospice nurse who ran through the advanced decision and went through the possible care he'd need in the future. And she acted as the witness to the legal document. And she was a brilliant person to go through this. Although it's a legal document, an advanced decision, she was a perfect person to do it, because she knew his diagnosis, she knew the treatment, and she knew what treatment would have on his specific disease. And as I said, I am quite passionate about letters of wishes because I think they add a bit of meat to the bone. They explain why you've made the decision, why you've picked the attorneys, why you've made the gifts you've made, and what have you. So with your health, the core documents is the power of attorney, the health and welfare power of attorney. So that's the who speaks for you. The ADRT, that's the advanced decision to refuse treatment. That's if I think it's perfect if you've got a diagnosis, you know a treatment pathway, and you have very firm views on what you don't want, for example, not being resuscitated. And also my husband having cancer, he had quite a firm view on the point during his illness journey where he no longer wanted people to be pumping him full of chemotherapy and what have you. Now, the advanced decision document, the lawyers are the best people to do the power of attorney document. The advanced decision document, as I said, perfect person is if you've got a community nurse. But if you want to have a look and see what it's about, the advanced decision document about refusing treatment is free on the Compassion in Dying website. So you can go in and there's loads of information if you're interested on the health side. And then ACP is the advanced care plan. So it's about the additional care and wishes for the end of life. And the best person to do that is the GP or a medical professional. So really quickly, the last couple of minutes, practical SADMIN is all the stuff people know in order to be your executor and be your attorney. To be honest, lovely financial advisors can probably help you with some of this. So it's the insurances, the pensions, the death in service, the nominations. Have you done the nominations? Super, super, super important, because whether assets pass in your estate or outside your estate for inheritance tax purposes is really important to understand. That's with regards to insurances and pensions and things. Really important to get your head around budgeting, accounts and tax, so that if you need someone to help you in your lifetime, an attorney, or on your death, an executor, everything's neat and tidy. And, you know, people often are so obsessed with thinking about their wills and powers of attorney, they forget about the household utilities, like telling people where the stopcock is, like really straightforward stuff like that. And obviously diarising to update, to review. And one of the things that is massive for me is communication. There is no point doing all of this, putting the hard work into all of this if people don't know about it. So Clearcut have a form. I think they call it a what I have and where I keep it form. I think Jane will send it out to people. But it's really good because it enables you to specify what you've got, where it is, and people can find it. And why I put business card there is you could have you know, your IFA business card, your lawyer's details, all there. You could even give them to your executors, your children, whoever, spouse and what have you. And best practice is to share this information with at least one trusted person or family member. The health stuff, really important to give the health and welfare lasting power of attorney and the advanced decision and any health advanced care plans. That's all for the GP. And they do actually put it on your record, and they do make it available, so the hospices should have that information pulling through if they're linked into the NHS, so that it does go to everybody. Anybody who might be involved in care, and I think it's really important, you're asking people to do a really important job being your executor, administrator, trustee and attorney. Really important to check in with them. They're okay doing the job, they know where to find stuff. Really, really important. I'm going to gloss over digital, but it's really important to just think about how do people know how to access your digital estate? Do they know your passwords? Do you want them to know? Do you actually not want them to know? Do you want it all to disappear on your death? What's happening with your social media? There are some brilliant legacy provisions. And then FIO, CALU, Life Ledger and Settled. These are all, and there's a whole new set of businesses coming into the market, which are all about helping on your death for people to find your details, but it's all digital. So it's all as good as you telling people. And similarly, ACP software is the advanced care plan software. But again, it's all jolly fine having your advanced decision and statement all on digital. People need to know how to find it and how to access it. But your digital assets are the possessions that you've purchased, stored or created or available online. So they include so much, as well as your bank accounts and your investments and what have you. It's things like your social media profiles, online conversations, photos and videos, gaming profiles, websites, shopping, memberships, email. And I think it's becoming more and more topical to work out what's going to happen to this on your death. How long is it kept for? Who can access it? And the last part of my SADMIN is the emotional part. And this is where I'm a massive believer in letters of wishes. You do them with regards to your wills and trusts so that people understand why you've made the decisions you've made in your wills. It can save so many arguments. It means you don't have to necessarily have all the tricky conversations now, although it's better if you can. But if you write it down, it's almost like a witness statement from the grave, explaining why you've made the decision you wanted to make in your will. Powers of attorney, the letters of wishes help people know all your health and welfare wishes, where you want to live, whether you want to be taken outside every day, whether you just what food you eat, how you want to be cared for, and with your assets, how you do your investments, who your financial advisor is, all that sort of stuff. Personal possessions, who's going to get what? If nobody wants anything, do you want it donated to a certain charity? Do you want them just sold and the money to fall into the pot? Funerals, have you got wishes on what you want to happen on your funeral? Pets and children, what's going to happen to them? People get quite emotive about that. And ethical wills is all about recording family stories. Do you want to pass on down the generation? A little bit about your philosophy, your legacy, your goals, stories about what you did when you were younger and what have you. And the reason all of this is important with the memory boxes, the letters, the gifts and the vlogs goes back to what I said at the beginning about those continuing bonds. This emotional TLC that you put into the extra stuff around your will and power of attorney is how you will be remembered by your loved ones. So the people you've left behind, they're going to carry you in their memories. What you choose to leave behind is for them. It helps them with their grief. It helps them in their healing. It helps to bring them comfort. And it may even help people you've never met, great-grandchildren, great-great-great-grandchildren. So it's really important not to forget to actually finish doing all of this. It seems loads. Celebrate the wins, celebrate what you get to do. New daily habits, I often tell my clients to have a life admin day every now and then where you catch up on everything. You make those phone calls, you look at the paperwork, you file stuff away. I have a bit of a one-touch rule. So post comes into the house, I try and touch it once. I open it, it either goes to the bin, gets shredded, goes into filing, or goes into a pile to be actioned, or if I can deal with it straight away, I will. Maybe a monthly catch-up time is more better. Literally diarise into your diary a day where you can properly catch up. And I'm a big believer that you need to cast your eye over all of this once a year, but at least every time you have a big change or every 2 to 5 years. And don't forget to communicate it. So I wanted to, I'm slightly running over, but I'm going to just quickly go into a few mind monkeys. I don't believe that the paperwork is difficult for the professionals. So if it's not difficult for professionals, why do people get so stuck on this? I think people worry about cost, but I would just like to leave you with the thought that I remember how much it costs when it goes to litigation, and it is substantially more. I think there's a lot of reluctance about the topic and a lot of misunderstanding, and that's where I love helping people to reduce the knowledge gap between them and the lawyers, so they feel more empowered and more knowledgeable when they go and see solicitors, because I think there is a solicitor reluctance. I think people worry they're going to get bulldozed into something that may not suit them, but the solicitors are trying to act in your best interests. They're not going to try and get you to do something that doesn't work for you, especially if you go to someone who's a step qualified or lifetime lawyers, because they've done extra exams in all of this. I understand the fear that people think that it might be tempting fate, but sadly, everybody is going to die someday, and there's nothing we can do about that. And there's a fear that is complicated, but it's more complicated if you put it off. Often people think that they are maybe too young, they try and do it perfectly, but actually, ironically, they put it off and procrastinate, leading to overwhelm, leading to confusion. And if you leave it too late, it gets very, very stressful. I remember what it was like to be called to do deathbed wills, and actually as solicitors, we didn't like doing them. Our insurers didn't like us doing them, and they were very, very expensive. And then that can lead to guilt and shame. And actually, there is no judgment. This is really hard. And that's why I've got this talk on today, why Jane's asked me to speak and what have you. These are some consequences of procrastinating. So a deed of variation, which is where you vary a will, had to be done for a farmer because he died intestate, so without a will. And what the laws of intestacy did was not sufficient for his family. So luckily everyone was in agreement, but that was an interesting one to solve. There was a granddaughter who was very stressed because there was a DIY will which had not been executed properly, and because they'd done it themselves, the whole will was void. There was a son he'd got a professional will done, but he'd not been appointed as an executor or trustee, and he was incredibly angry about it, and he blamed the firm. But actually, when we got under the, well, when I used to often get the complicated files, and when I got under the skin of it, I realised that actually what he was really upset about is he thought because he wasn't appointed, his dad didn't trust him, and actually that wasn't the case. And once he realised that wasn't the case, it was quite easy to calm the waters on that one. A son, there was no lasting power of attorney. I did a court protection application actually for welfare and for finance, which is very unusual to do it for welfare, but we were successful with both. But the waiting period was very, very stressful because obviously she was living alone with no capacity. And there was a bit of a safeguarding issue as well that we had to look after. So had she had a power of attorney, she would never have been on her own. She would have been moved into a much safer housing, but no one could agree on where she should go. So again, another, please do your powers of attorney. A wife, not enough information about a funeral. This was actually a cruise client. She'd got her client buried and she wished she'd got him cremated, and that really complicated her grief, but he'd never said whether he wanted to be buried or cremated. Partner with no digital legacy manager is me, because we'd done so much with my husband, but we hadn't sewn up. I mean, it was 8 years ago. It wasn't, nobody was on the ball as much as they are now, and there was a few digital legacy things that went wrong because Simon hadn't put things in place for what should, and I'm meaning social media type stuff, so it's not big, but it was massive for me and my grief. So it's more than just the legals, it's the stress and it's the legacy. One of the things I do is I do a free will challenge once or twice a year, and the common mind monkeys of the blended families, of the who to appoint, of people being not engaging or not around, of not understanding how the property is held, maybe the property being in a sole name when you don't want it to be, foreign assets, business and illness. These are often the reasons why you actually need to do it. The whole reason that you're struggling with it illustrates that it's something that needs to be sorted. And I really believe that the most difficult things are the ones most worth doing. So my why is to have everything sorted for my kids. God forbid I'm not here, they'll be orphans. So the elephant in the room is sorting out the tricky stuff. In looking at it all in one go seems absolutely massive. So actually what you need to do is plan. You need to work out what you need to do and how to do it. You then need to break it down, and breaking it down is literally the gold dust, because if you look at it in one massive pile, it's huge, and breaking it down makes it so much better. Get the right advice and support. Clearcut can help with the investments. I can help with the mind monkeys. Lawyers can help with the drafting. Take that action and then diarise those reviews. And it's really important to do it now. It will bring clarity on what the priorities are. It will help you organise your paperwork. Bizarrely, talking about the really tricky things can actually bring you closer to other people, because you've not got that elephant in the room anymore, and it can bring more resilience for conversations in the future, and obviously peace of mind and relief. So people can either do it themselves, sort through it themselves, or they can get some help and commit to sorting it all out and getting that emotional handrail sorted. Small steps, easy wins. I think setting the emotional stuff aside, leaving the emotional stuff to last is really important. So the will and the power of attorney are the most important things to get done first. Accept it's going to be uncomfy. Remember why you want to do it, because when it gets hard, why you want to do it will keep you going. Loads of self-love, because I'm a rainbow kind of person. And rainbow as in rainbows come out after the storm, not for any other reason. Celebrate with the rewards and the treats and accountability. So I think it's really important, try and close that knowledge gap, have someone who can listen to you. Person-centered, I'm sure Clearcut are like that, but is people going on your pace? And apologies because I've given you a lot today, but help breaking it down, help with the accountability. And I think this is pretty much my last slide, but obviously Clearcut and financial advisors can help you with all the investments. I can help with all the mind monkeys and the practical side of trying to break it all down and working out what the priorities are. For lawyers, lifetime lawyers used to be called solicitors for the elderly. STEP is Society of Trust and Estate Practitioners. And as a lawyer, I used to be a member of both of those. Both of those have a Find a Lawyer website. And you can go in and find a professional who's got both or one or other of those qualifications in your area, and you know you're getting the kind of Gucci label of lawyers. And obviously SOLA is Society of Later Life Advisors, and they're financial advisors, but you don't need that because you've got ClearCut. For mental health, don't forget, this is hard. So places like Samaritan and Mind are there. And also for additional support and information around the end of life stuff for free, there's lots on my website, but also cancer charities, local hospices and Age UK have loads. And like I said, Compassion in Dying have loads of free content. And I think sometimes that's the problem, is there's so much out there, knowing where to start. Last slide, Dr. Catherine Mannix is the most amazing palliative care consultant. She's started up a massive conversation about talking about a good death. But she said how grateful we'll be on our last day that we took the time now to plan ahead. And I hope if you take nothing else away from today, is to work out what your priorities are and what one step you can take today, this week, to help taking you a step closer to do that planning and get things in place. So that's me. I'm tempted to stop sharing my screen so that I can see people properly. Apologies that I've taken up so much time, Jane, but I do have time, if other people have time, to hang around and answer questions.
Oh, thanks, Emma. That was fabulous. I can't believe how quickly the time went. It really did, and it was a really interesting presentation with lots of useful tips. We have got a few questions here, so I'll pick some of those out if people are happy to stay on for a little while longer. So we've got a question here from Paul. What is the time limit to pay inheritance tax after death?
So I normally try and say you've got to do everything within 6 months, because then interest and penalties come due, but please don't quote me on that. I am a few years out of the game now, but generally 6 months is, lawyers can help you out, but I would definitely go check out that one with a lawyer.
Yeah, I think it is due, isn't it? 6 months after date. Well, it's the month at the end of the month after the date of death, 6 months after that. Nothing's changed on that front.
Not too out of date.
Another question was that's come in. We did our wills 20 years ago when we had young children. Are they still valid, or do they need updating?
So as long as you haven't got married, because obviously marriage entirely revokes a will unless it's written in contemplation of that marriage. But in those 20 years, it possibly is still valid, but the difference between valid and workable is massive. So do you still want the people who you've gifted things to be the beneficiaries? Have there been any massive life changes like deaths and births and or, you know, have you given a big gift in your will that's changed? Also law changes. So, you know, the powers of attorney is a perfect example, but the law can change. With wills, the fascinating thing is it used to be quite trendy to put nil rate band discretionary trusts for inheritance tax planning into wills. And sometimes now they can complicate things, sometimes now they can still have their place. But a lot of lawyers will let you take the will to them and you can explain what your situation is and they can tell you whether you need to update it or not. It's also quite tidy. I mean, I've done 3 or 4 wills and I'm only in my 40s. And each time I have a major life change, I basically update my will.
Thank you. There's a few questions about enduring power of attorney and the changes to lasting power of attorneys, which we have now. So I can bundle a few of those together. Did the change from enduring power of attorney to lasting power of attorney change anything else?
So the change was really fascinating. The old system of enduring powers of attorney only dealt with finances. They also did not need to be registered unless you lost capacity. And so people were worried about abuse by attorneys because they didn't have to be registered. So there was no like big database of all the attorneys. So they brought in lasting powers of attorney, which do health. But also lasting powers of attorney have to be registered in order to be used. And so an old EPA may still be okay if it was validly executed. You still want the same people to be your attorney, but you've got to realise it's only your finances. So often it's actually worth doing new lasting powers of attorney.
So I think you might have answered the next question. Is my wife and I have mutual powers of attorney from 2007, which I'm assuming is enduring powers of attorney, but I have not registered them. Are they still valid?
Yeah, so you haven't registered them because EPAs, these 2007 and before, didn't have to be registered unless the rule was is attorneys have to register an EPA, an enduring power of attorney, these old ones, if someone has lost or is losing capacity. So unregistered, they're fine as long as you have capacity, but it's whether they're still workable. So again, I would take them to a lawyer and I would just say, A, these don't cover health. I need health LPAs, and B, do these still work? Because there are reasons why it might be better to have a new finance LPA instead of the EPA.
And names and addresses are out of date. Can we amend them ourselves, or do they need witnesses?
So with both your powers of attorney and your wills, I used to have people come to me saying I need to update everything because of changes of address of the beneficiaries or the executors or what have you. You don't have to change the legal documents, but what's really helpful is to put a letter with the original will or original power of attorney with all the new details, because otherwise people aren't going to know who to contact or how to contact them. But it's not necessarily a trigger for doing new legal documents.
I understand there are now two types of power of attorney, again, enduring and lasting powers of attorney, financial and medical. Can we add a clause to our existing power of attorney to make them medical, or do we just start again?
No, you cannot make an EPA into a medical power of attorney. An EPA is an EPA. You can't change it. In fact, I don't really think you can add powers of attorney, which is a real pain, but you can put replacement attorneys in. So you can kind of, and I would really encourage people to think about replacement for a lot of these roles, attorneys and executors, so that you put your first choice, but God forbid your first choice can't do it. You've got a replacement in there. But no, an old EPA basically needs to be redone as a new lasting power of attorney.
And a question about powers of attorney again. How many people can you have as power of attorney? Is there a
Really
limit?
fascinating question. So with the attorneys, it's important to think practically. A, do they all get on? B, are they all in the country? Because actually, if they're outside the country, that can add a complicating factor. And we used to, as lawyers, say any more than 3 or 4 starts to get a bit unwieldy. But you may want to either appoint 3 or 4, but say that one person is to take the lead and the others are just there as support, or have, say, 2 primary ones with 2 replacements. Up to you as to your family circumstances and how people get on within the dynamics, really.
And finally, a question from me. If, since you can do your lasting power of attorney online through the gov.uk website, would you suggest that people complete their lasting powers of attorney themselves, or do they still need to go to a lawyer to get them done?
Oh, do you know, Jane, this really makes me struggle because I'm so aware of the cost. I'm so aware that if you go to a lawyer, it's going to be more expensive for wills, for powers of attorney, for the lot. And the government seems to be on this mission to say everyone needs to have a power of attorney. So you can go online and you can do it yourself. But all I'll say is I wouldn't cut my hair myself. I would pay to get my hair cut and coloured. It's not what I know that's going to trip me up. I don't know. And it just worries me. And having been a lawyer, what was fascinating, I worked at quite a shiny firm at one point, and I was only there for a number of years because it was just at the period that Simon died, and then I moved to make things easier for the family. But in the short period I was there, where we were as the private client doing wills and powers of attorney was, say, this big, and to begin with, the contentious guys were this big, and in the few years I was there, contentious grew 3-fold. And I think it's because more and more people are doing it themselves. So you're not going to, and sadly, people only find out what's gone wrong when there's a lack of capacity or something, right? And then it's too late. So I am a big believer that yes, it's more expensive, but you get what you pay for getting a lawyer to do it.
Yeah, no, thank you. Thanks for that, Emma. And I think that probably we've overrun a little bit this morning. I think we could sit and ask all these questions and talk, and there's a lot more I think that you could talk about. But it's been a really interesting presentation, some good tips. Thank you for sharing your personal journey with us, because I think that's, you know, sort of really brings it home why this is so important. I'm going to let everybody go now and enjoy the rest of the day and the sunshine. And I think a good tip that you just gave us was, you know, maybe you put some time in the diary to get these documents and things sorted out, or come and talk to us about it. Thank you everyone for attending. If there's any questions, please drop us a line afterwards. We will make Emma's presentation today available. It has been recorded if anyone wants to dip in again and listen to any part of it. So I'll leave you all to go and enjoy the sunshine. Thank you. Bye.